The Supreme Court is preparing to decide whether states can ban America's most popular rifle, the AR-15. This isn't a hypothetical scenario. Multiple states have already enacted such bans, and now the nation's highest court will consider whether these restrictions violate the Second Amendment. What makes this moment particularly significant is that the court may finally be ready to address an issue they've avoided for years. On December 15th, the Supreme Court will conference on a critical challenge to Cook County's assault weapon ordinance. The case is Herrera versus Cook County, and the petitioners are individual citizens along with organizations like the Second Amendment Foundation. They're challenging a law that criminalizes the sale, transfer, or possession of approximately 100 rifles by name, plus any firearms with certain features like pistol grips, folding stocks, or flash hiders. This case may finally fulfill a promise made by the court when they denied review in the Snope case last term. Justice Kavanaugh indicated at that time that the court would take up a rifle ban case in a term or two. The petitioners argue this is the right case at the right time to make good on that commitment. The legal journey that brought us here began in 2021 when the lawsuit was filed in federal district court in Chicago. While the case was pending, Illinois enacted a statewide assault weapon ban in 2024 that overlapped with Cook County's existing restrictions. The turning point came when the Seventh Circuit decided Bevis versus Naperville, upholding Illinois' law on the grounds that AR-15s are too militaristic, essentially military arms unprotected by the Second Amendment. The court ruled that firearms useful in military service could be banned or restricted by the government. This was a significant departure from how many Second Amendment advocates understood the Heller and Bruin decisions. Bound by this Seventh Circuit precedent, the district court had no choice but to uphold Cook County's ban. The district court issued summary judgment in favor of Cook County, finding that the rifles in question fell outside Second Amendment protections. After the Supreme Court denied the Snope petition in 2025, the Seventh Circuit affirmed the lower court's decision on review. The appellate court leaned heavily on the Bevis ruling, treating AR-15s as civilian versions of the M16 and placing them outside constitutional protections based on their supposedly militaristic nature. Now the petitioners are asking the Supreme Court to resolve a fundamental question that affects millions of Americans. Do citizens have a constitutional right to own semi-automatic rifles like AR-15s and AK-47s? Their petition makes several compelling arguments that challenge the reasoning of the lower courts. First, they argue that the circuit courts are divided and confused about how to apply the landmark Heller and Bruin decisions. Different circuits are reaching different conclusions, and there's no consistency in how these constitutional questions are being answered. The petitioners present extensive evidence to support their position. They've submitted surveys, production data, and sales figures showing that tens of millions of AR-15s are currently in circulation, owned by law-abiding Americans for home defense, target shooting, hunting, and other lawful purposes. This data is crucial because it goes directly to the question of whether these rifles are in common use for lawful purposes, which is the standard established in Heller. If tens of millions of Americans own these rifles for legitimate reasons, the argument goes, then they cannot be considered unusual or outside the scope of Second Amendment protection. Another key argument challenges the very foundation of the Seventh Circuit's reasoning. The petitioners argue that the useful military service analysis employed by the Seventh Circuit was never actually part of the Heller or Bruin framework and should be rejected. They emphasize that we're talking about semi-automatic rifles, not M16s. The fact that a firearm may share some cosmetic features with a military weapon doesn't transform it into a military weapon. The functional differences between a semi-automatic AR-15 and a fully automatic M16 are significant, and conflating the two represents a fundamental misunderstanding of both firearms and constitutional law. Perhaps most powerfully, the petitioners argue that if the most widely owned rifle in America isn't protected by the Second Amendment, then under this logic, no firearm is truly protected. This is the logical endpoint of the reasoning employed by Cook County and affirmed by the Seventh Circuit. If common ownership and lawful use aren't sufficient to bring a firearm within the Second Amendment's protections, then what firearm could ever be safe from prohibition? Cook County, of course, has responded with its own arguments for why the Supreme Court should deny review. They make three primary contentions. First, they claim there is no circuit split requiring Supreme Court intervention. According to Cook County, every federal appeals court that has addressed assault weapon bans, including the First, Second, Fourth, and Seventh Circuits, has upheld them under Bruin. This consensus among the circuits, they argue, eliminates the need for Supreme Court review. If all the circuits agree, then there's no conflict for the High Court to resolve. Second, Cook County contends this is a poor vehicle for Supreme Court review due to procedural defects. They claim the petitioners made errors in the litigation below, including skipping discovery and failing to submit admissible evidence to support their claims. These procedural problems, according to Cook County, make this an unsuitable case for addressing such an important constitutional question. Third, Cook County maintains that the lower courts reached the correct conclusion on the merits. They argue that AR-15s are dangerous and unusual weapons, closely related to M16s, and therefore fall outside Second Amendment protections under Heller. They also contend that the historical tradition of firearms regulation in America supports restrictions on militarized weapons. In their view, there's nothing novel or unprecedented about the kind of restrictions they've imposed. What makes this case so significant is its potential reach. This isn't just about Cook County's ordinance. A Supreme Court ruling would affect Illinois' statewide ban and similar laws in California, New York, New Jersey, Washington, Colorado, and other states with assault weapon restrictions. The court essentially has two options. They can validate these bans nationwide, settling the question in favor of state authority to regulate these firearms. Or they can strike down such bans once and for all, establishing clearly that semi-automatic rifles like the AR-15 are protected by the Second Amendment. Until now, the Supreme Court has consistently avoided rifle and magazine ban cases. While they've accepted two Second Amendment cases this term, neither addresses the question of arms bans or characteristic-based restrictions. One case involves concealed carry restrictions from Hawaii, and another deals with prohibitions for certain classes of individuals. Important as those cases are, they don't answer the fundamental question of whether states can ban entire categories of firearms that are in common use for lawful purposes. We'll learn the court's decision shortly after the December 15th conference, typically within 1 to 2 weeks, depending on the release schedule. Whether Justice Kavanaugh's promise to take up this issue in a term or two was genuine, or just another delay tactic, will soon become clear. The answer will determine whether millions of Americans can continue to own the rifles they already possess, or whether states have the power to ban the most popular firearm in the country. This case represents a critical moment for Second Amendment rights, and whatever the court decides will shape firearms law for generations to come.